Hello and welcome to Dorsey's Public Finance Group Annual Training regarding municipal securities disclosures. I'd like to introduce David Grossklaus, a partner in Dorsey's Public Finance Group. Dave?
Good morning, and thank you everyone for joining us today. As Rima said, this is our Municipal Securities Disclosure 2022 annual training. Some housekeeping matters to point out as we get started here. We're going to try to keep this to the scheduled time of 60 minutes. For materials and attendance forms, those can be found at events@dorsey.com. And you can return your completed attendance form to attendance@dorsey.com for those folks at issuers who are attending this for annual training in compliance with their continuing disclosure policies, which we'll delve into much more. We certainly hope that this is informative, but also for you folks, but also informative to us. And one of the ways that it's helpful to us and hopefully the group is if we have some questions. So we're going to ask that you please email James Smith at smith.james@dorsey.com to the extent you have any questions as we work our way through the materials. I'm going to speak to you today along with my colleagues, as I said, James Smith, a partner, and our colleague Jennifer Block, who's a senior attorney in our office. Many of you have had the opportunity to speak to either myself or Jennifer or James on these matters, and so we're each going to take a part in this discussion. Let's talk first about some real basics that we're going to overview for you. First will be disclosure basics. We're going to highlight some recent amendments, which are now not quite so recent. The amendments from 2019, commonly referred to as the material events 15 and 16. James is going to talk a little bit to you about the role of the SEC. Jennifer's going to speak to you about policies and procedures, and then, as I said, we'll roll that into a Q&A session. So first of all, let's talk about some high-level glossary of terms, roles of counsel, and the federal regulatory framework. So let's talk a little bit about the forest, so to speak, and let's start with the fact that governmental entities or the issuers of bonds being a security, must comply with a number of different sets of rules, securities rules in this case, as they issue the bonds. The first place that we always want everybody to understand is that the issuer or the governmental entity of the bonds is always responsible ultimately for all of the things we're going to talk about today. And obviously, issuers hire any number of different entities to help them as they work through the process, whether it be counsel, disclosure counsel, whether it be municipal advisors, and or whether it be the underwriters or the investment banks who are going to ultimately sell the bonds. So there is a commonality of interest amongst all those parties. We all want to make sure we're getting things correct, being accurate, and making sure we're appropriately disclosing both primary and secondary disclosure information. However, it should always be remembered again that the ultimate responsibility for all this always lies with the governmental issuer. Let's move down a little bit further and then talk about two overarching concepts with regard to disclosure that we're going to talk about. And just to frame this, I'll refer to it as primary disclosure and secondary disclosure. So Primary disclosure is that point in time when you're originally issuing the bonds. And with respect to primary disclosure, you're going to hear words like 10b-5, which I'll talk a little bit about in a minute, and concepts of due diligence. So this is when you've initially issued the bonds, and you'll have offering documents that you'll be working through in order to go out into the market and sell the bonds. Secondary disclosure, a different rule applies there. It's Rule 15C212. And secondary disclosure applies to the situations now you've issued your bonds. You may be 2-3 years out from the time you issued the bonds, and but contractually through continuing disclosure certificates or agreements, you are responsible to provide updated information going forward. This is a growth area significantly for the SEC, partly because now bonds are traded much more on the secondary market. And so that's continuing disclosure, and that's Rule 15C212. So let's dive in here on some glossary of terms then, with that as the context. As I said, issuer, as we're going to refer to it, will be the governmental entity. The underwriter is the purchaser of the bonds. The underwriter is going to purchase those bonds for a brief time. Ultimately, the bonds are going to be turned back around and sold off to investors out in the public domain. Municipal advisors advise issuers about municipal securities. And then, of course, this all is overseen and regulated by ultimately the SEC. In some respects, just know that the SEC's regulatory framework for issuers on the primary level is Rule 10b-5, which we'll get into. With regard to SEC oversight of issuers in the secondary market, that is really done through underwriters who must have a contractual obligation. That contractual obligation, either the CDC or the CDA, is the authoritative document that then binds the issuer to have to comply with secondary disclosure. You'll hear us today refer to POS and OS, or OS. That's the offering document that for folks who have issued bonds in the past have seen, and that hopefully or certainly should be reviewed by the governmental officials and the issuer staff who is responsible for issuing the bonds. As I've said and referred to, a CDC or a CDA, one and the same. It's either a certificate or an agreement, depends slightly on the structure. Lastly, the entity I haven't, or the document I haven't talked about, is a dissemination agent agreement. This would be an agreement whereby the issuer would enter into an agreement with a third party, whereby that third party is responsible to file continuing disclosure information of the issuer onto EMMA. For those of you who haven't looked, and I'll just touch briefly on EMMA. EMMA is the website or portal pursuant to which issuers are directed to provide continuing disclosure information to the marketplace. The private side, private company side, it's referred to as EDGAR. In the municipal side, it is the EMMA system. I always urge folks, take a look as an issuer at the EMMA website. Usually I think you'll find it to be just kind of an interesting 10 or 15-minute viewpoint to see all the information on issuers that is downloaded by requirement or can be downloaded as a voluntary filing. Let's talk a minute about the roles of counsel. This is another area that has really developed and changed and kind of morphed through the years, largely because of much more SEC activity with regard to disclosure. So bond counsel, as many of you know, over the past many years, that I would refer to as tax counsel. Bond counsel looks at the tax qualifications. Bond counsel prepares all the resolutions that you folks adopt when you're issuing bonds, making sure that they're compliant if they're tax exempt with the federal tax exempt regulations, makes certain that they're compliant with any state law rules that we have in terms of holding hearings, those types of things, and then generally drafts closing certificates related to the bond issuance. Ultimately, the bond counsel will issue an opinion that says specifically that the bonds are legally and validly binding enforceable obligations of the issuer. And then to the extent the bonds are tax exempt, the opinion will also state that in the opinion so that the holder of the bonds can claim the federal tax exemption. With respect to disclosure counsel, and again, disclosure counsel at the most basic level is counsel who's advising with respect to securities laws, as opposed to bond counsel who's really advising with respect to tax laws, has a little different role, obviously. Disclosure counsel is going to be assessing the risk, looking at the offering document to make sure you're meeting 10b5 compliant rules, which I'll talk about here in a minute. Disclosure counsel also takes a very hard look to make sure the CDC that is being prepared with respect to the offering is compliant with respect to Rule 15C212. Disclosure counsel will prepare and work through due diligence, which is a lengthy checklist. Disclosure counsel will run usually a due diligence conference call, all driving towards ultimately the opinion by disclosure counsel of the 10b5 opinion. And so where bond counsel is providing a tax opinion, disclosure counsel is providing a securities opinion, a 10b5 opinion. In addition to this, just to be also clear, as I said earlier, this is a joint, these are legal decisions, legal opinions. In conjunction with providing opinions, obviously, the entire group is working with the financial folks to make sure the financial information for the issuer is also appropriate and accurate in the official statement. Let's talk a little bit about the federal regulatory framework. Again, I've alluded to 10b5. This concept goes back to the 33 and 34 Act. And the essence broken down, as you see before you, of Rule 10b5 is that there should be no false or misleading statements or omissions of material fact. This is the sole driver for due diligence. This again is ultimately when bonds are marketed in the OS. This is the ultimate statement that everybody involved is making, that the issuer is making with regard rather to that offering document. So we're saying to bondholders, essentially, we have told you bondholders or potential bondholders everything we know that we believe is material to this issuance, whether it be risks and whatnot, describing the structure of the indebtedness, the pledge of security, and so on and so forth. And to our knowledge, we're not aware of any statements that would be false or misleading. As equally important, and another significant role of the due diligence process is to make sure there's no omission of a material fact. So oftentimes I refer to this concept as a requirement to provide to prospective purchasers or bondholders the good, the bad, and the ugly. right? There's the omission, I would submit to you, is probably one of the most significant factors of due diligence, whereby we ask a lot of questions. We have conference calls, working again jointly with the municipal advisors and the underwriters, again, all with the goal to make sure that the document or the POS that's going out to the street to sell the bonds meets this 10b5 requirement. The consequences are, quite frankly, scary, and the consequences in the municipal market have been ratcheted up, especially over the last 5 to 7 years by the SEC. And James is going to touch on this a little bit more, but you can see here, individuals can come into problems with the SEC with respect to either civil or criminal penalties, certainly reputational harm as part of that. The most important thing to understand for elected officials, for staff, for everybody involved at the issuer is that there can be personal liability. James will talk a little bit more about this. I don't want folks to run to the hills screaming and never do another issuance. It's just something everybody needs to understand, and also understand that that is why this is a joint effort, and why you hire professionals to help make sure that the 10b5 standards are being met. Let's talk a little bit then in the federal regulatory framework again about the secondary market rules, or Rule 15C212. Actually, as I said earlier, 15C212 is a rule that is applicable to underwriters. It is the underwriters who are not allowed to sell bonds unless and until they know that the issuer has been contractually obligated to agree to provide certain ongoing information. Under the SEC framework, technically the Tower Amendment, the SEC does not have direct control over issuers. This is something that's always a little confusing to folks. So the SEC years ago, late 90s, devised obviously the SEC has very direct control over underwriters. And so in the late 90s, the SEC, to work their way around the Tower Amendment to have access to issuers, devised within the Rule 15C212 that underwriters literally cannot purchase bonds unless they have a contractual arrangement with the issuer to actually provide continuing disclosure. Thus, what is technically an indirect responsibility of the issuer is now made direct. As you see here, underwriters must reasonably determine that the issuers commit to provide annual financial information and then material event notices. Jennifer and James will talk a little bit more about that. The rule, just at a broad level, is that this information, annual audits be provided, and with respect to material events, which we'll talk more about, that those be filed on EMMA within 10 business days of their occurrence. That can sometimes be a tricky determination. We'll talk more about that. I'm going to move here a little more quickly because I see my time is moving quickly. As you can see here, with regard to disclosing under Rule 15C212, the final OS must disclose also material noncompliance with your prior continuing disclosure look back period of 5 years. This is a very new phenomenon over the past 5 to 7 years since MCDC of the Securities Commission was brought forth. And so, but it is now something for which any number of issuers get penalized, and some, quite frankly, significantly. Let's take a very quick run through 15C212 listed events or material events. We'll talk more about 15 and 16. I'll point out just a couple. Many of these are rather obvious, and I would certainly hope that the folks on this phone call do not run into these. These are required to be in your continuing disclosure certificate. These words cannot change per rule. Most of these, as you can see, would be the types of things that I think would be kind of no-brainers, that if you don't pay your debt, you need to disclose that to bondholders. In the first 14 or so listed events, the one that we see that is sometimes a trap is number 11, rating changes. It's a trap not because it should surprise anybody that if there's a rating change that you would have to provide information. The trap is that normally you think of negative events. So if you have a rating downgrade, but in this case as well, an upgrade is an event that needs to be disclosed within 10 business days of its occurrence. So one of those oddities that good information, the one piece of information here where good information is actually required to also be provided. Let's move on. As I said, to recent amendments and some of these new events, let's focus real quick on 15 and 16. The purpose of these additions in 2019 were to try to capture direct loans or financial obligations that issuers might enter into, but that might otherwise not necessarily be out in the marketplace, so that bondholders would know about it, or might occur within a gap between when financial information of the issuer is required to be filed on an annual basis from the point at which the end of the fiscal year may have occurred. The tricky parts about event 15, first of all, determining what is a financial obligation. I would submit to you that if you have something that looks like it's a payment of money over more than a fiscal year, you should consider whether that's a financial obligation. And secondarily, to the extent you have a financial obligation, the next analysis is whether that financial obligation is material to the issuer. These, I would suggest to you, are reasons to pick up the phone and call us. I hesitate to think that an issuer on their own should try to be defining for themselves whether a financial obligation exists and or whether it's material. Secondly, under 16, you see here, to the extent you have a default, an acceleration, a termination event. The tricky one here, I would suggest, is modification of terms of a financial obligation. So if you change certain terms, interest rates, or other key terms of a financial obligation, that might be a reason to have to disclose. I will just tell you, to the extent it's tax exempt debt, you also have a tax reason that you should pick up the phone and call us. But keeping this in the securities framework, to the extent you're modifying terms of a financial obligation. And then lastly, this part is to the extent it's because of financial difficulties. So hopefully you won't see as many events that are event 16 events, because ultimately that filters out to an event that is a result of financial difficulty. I'll let folks take a look more specifically at those definitions. As I said, with respect to interpreting events 15 and 16, please take a look at some of these items. Don't ever hesitate to give us a call. to talk about especially event 15 and whether you one have a financial obligation and whether it is material. Very quickly, I'm going to move over to compliance considerations with time running short. As you see here for issuers, one of the first compliance considerations is adopting procedures and policies. First and foremost, to comply now with new rule for material events 15 and 16. And then also to consider a framework with staff and others about how you make sure that if an event occurs, who's responsible and how do you work to make sure that a filing with respect to those material events will, one, be noticed, and two, be filed within 10 business days of its occurrence. Another consideration here for issuers, as you can see with the increased rules from a regulatory perspective, it is increased due diligence with respect to underwriters, but also with respect to issuers themselves to make sure that everything that's being disclosed is accurate and appropriate. Compliance, as you can see, really key for internal discussions, tracking, making sure any of those events that may have occurred are known and known by the right people as soon as possible. And lastly, again, I can't emphasize enough an understanding and recognition of the separate roles of counsel now, separate role between bond counsel, separate role between disclosure counsel, and making sure that you understand what those folks are doing in different capacities, and especially understanding for disclosure counsel the kinds of protections that you're getting from disclosure counsel to provide a 10b5 opinion. And that, I think, is something we can't stress enough, that with the growing activity of the SEC, we think it's just vital that issuers give strong consideration when they're going to be issuing debt to hiring us to serve in both capacities. So with that, I'm going to turn it over to my colleagues.
All right, thanks, Jennifer, and thanks, Dave. So I'm going to spend a few minutes just walking through what the SEC has been up to in our little part of the world over the last several years. And Dave certainly mentioned their increased interest in the municipal market. So we'll walk through some of that. This first slide, you can just go back over the last, starting in really 2013 and 2014. The SEC has paid more attention to the issuer side of the municipal market. Of course, they've always regulated and had oversight of the broker dealers, the investment banks, the underwriters. But now they've certainly paid more attention to the information that issuers are disclosing to investors through the issuance of bonds. And so this is really talking about, for the most part, the primary offering, or when you're issuing debt and we're working on the official statement and you're speaking to the investors, and back to what Dave talked about with making sure that the information provided is materially accurate and isn't missing or omitting anything. So some of you may remember the fun everyone had with MCDC, and that was sort of a big moment in our world where it was clear that the SEC was going to be looking to issuers with respect to statements in the official statement. Let's go to the next one. So we've got on here just a few recent announcements and trends, but at the end of the day, the bottom line is, once or twice a year over the last several years, the leaders of the SEC have come out with information talking to the municipal market and explaining to all of us and pointing out that they're certainly interested in watching the disclosure that is being made to investors on the municipal side. They're certainly talking about things such as financial statements. In the government world, it's fairly common for financial statements to take months into the new fiscal year. The SEC is for a while now encouraged everyone to try to accelerate the provision of that financial information. So that's something that we always keep in mind as we're working on transactions. And they're looking for potentially more ways to directly regulate issuers, but that requires some federal law changes. So it's one of those things we keep an eye on. But in the meantime, we know that when we're offering bonds and you as the issuers are offering, we have to pay close attention to that offering document. In 2020, this was a pretty significant pronouncement. Of course, when you're doing an official statement and offering bonds, you're speaking to the potential investors and speaking to the market. But the SEC now a couple of years ago made it clear that the anti-fraud rules apply in other situations as well when investors might be looking for information as to your issuer. So some examples that were included are municipal websites, making sure that the information there is accurate. Of course, many websites have historical financial information. That's fine, as long as it's clear that this is the FY19 audit that might be posted on a website. Hyperlinks, we're always a little bit sensitive to hyperlinks, just making it clear that if it's sending to something that is not the issuer's information, be very clear about that. They talked about summaries of financial information. The other part that's interesting are reports to state or local governments. And of course, in Iowa, we have the annual financial reports that are submitted. So because all of that is public information, it is possible that investors will look for that and they'll find it. And so you could be speaking to the market on an ongoing basis through some of that information. And so the bottom line with all of that is, of course, just being careful and reviewing that information and making sure it's accurate. And then there is potential, depending on the situation with respect to speeches or statements by elected officials, but that it depends on the circumstances. So again, you're always safe if the information being shared is accurate and factual. We're now, I guess, 2 years from kind of the start of COVID-related items, so I won't spend a ton of time on this slide, other than as we've worked on deals, we've certainly asked questions of the issuers and the finance team to talk about any impacts negative from COVID. A lot of circumstances with some of the federal money, it's not been negative for many issuers, but that's one of the things that we still talk about and we still ask. And to the extent there have been issues, it's one of those things that are disclosed in the official statements. So I'm going to spend the most time on this particular slide because it is just from last September. So it's the most recent SEC action that deals directly with a municipal issuer. So as you can see, the SEC entered an order in September against a school district in San Diego, both against the district and also against its now retired CFO. What happened here is the SEC said, you, the district, used stale and misleading information in that official statement when you were talking to the investors. And the facts kind of backing around this are, in March and April of 2018, the school district went out to issue general obligation bonds. As part of that issue, they included FY18 budget information and sent that to rating agencies, to their finance team. As part of that budget information, at the same time, the expenses for that fiscal year had been tracking in a way that was really no longer reflected in that FY18 budget. In fact, the budget projections showed a healthy general fund surplus, and by the time all this was said and done and the FY18 audit was prepared, it turned out they had a very significant deficit balance in their general fund. And what the SEC said is throughout that time of that fiscal year, the CFO and the finance department they knew because they had prepared reports and information about salary increases and increased expenses. And so they knew that the information in the budget wasn't accurate, and it was stale and no longer reflected the actual facts. And so the way this popped up is once the rating agency, a year later saw the FY18 audit, of course, there was a significant downgrade of this issuer's bonds. And then the SEC comes knocking on the door and says, well, look, between the district and the CFO, what you shared in that offering document for fiscal year 18 was stale and misleading and violated securities laws. And what they looked at here was negligence. They didn't say that necessarily the CFO or anyone at the district went out and did this with an intent to defraud investors, but they charged them under a portion of the law that just said they were negligent in their activities. And so the key here is, as we're collectively working on bond issues, it's another example of why we have to be very careful and cognizant of the information being provided and information that maybe wasn't provided. So if they were including the FY18 budget, but not also information about their experience that far into the fiscal year, that was the problem in this case. And as you can see, some pretty significant penalties. The district had to enter into a cease and desist order, hire consultants, do a bunch of, I'm sure, training. And then in time they're going out in the future to issue bonds, they'll have to raise their hand to the marketplace and say, hey, this happened to us, this is what we did. And then the former CFO agreed to not work on any more bond issues and agreed to pay a significant penalty as part of the transaction. So this is where Dave mentioned earlier that you've got some of the potential personal liability items that are frightening. And so I think this is why you just have to work through and understand the seriousness of the offering document, and that is speaking to investors. And of course, if anything is, if things go wrong, or that's when people really dig in and say, well, what did that offering document say? And so you want to be able to be comfortable that all the information there was accurate and fully disclosed. So with that, I'm going to turn it over to Jennifer to walk through policies and procedures.
Thanks, James. We'll get started here and talking about three different kind of bigger buckets related to policies and procedures for disclosure. As Dave talked earlier about primary disclosure for those new bond offerings, and then the ongoing disclosure or secondary disclosure once those bonds are out in the market. And then the third component being training such as this right now, and then ongoing training as those bonds continue to be outstanding. So if we first look at that primary offering component of the policy, there's 5 key steps. The first being establishing a plan and a schedule, and that's kind of getting all your ducks in a row, getting things organized, working with your finance team to make sure that you and everyone is on the same page for timing and expectations for who's providing what information and at what time. As you can see, you'll see a reference to a disclosure officer throughout these next slides. So it's a really key role, and someone who's really kind of the point person at the issuer for pulling this material together and keeping things on track with the issuer. So then the next piece of managing the process and preparing the OS, the offering document. This is looking at the document, reviewing it, making sure the information related to the issuer is correct, working with your financial professionals to ensure that the information in that back portion of the offering document in Appendix A is complete and thorough, as well as the other pieces in the front part of the offering document. But typically, we would see the issuer working quite a bit on gathering those financial and operating data tables and information. And then that third step is working through the review and the sign off. And this sometimes goes in conjunction with the due diligence process that has been mentioned already. And so oftentimes we'll be sending, in addition to a draft of the offering document, a due diligence questionnaire that's intended to help shape and guide what ends in the offering document. So that sign-off process is really important. It lets the finance team know that the issuer has reviewed it, and whether there are comments, edits, changes to it, or else letting people know that the document is ready to move forward. And so just that key communication throughout the process is very, very helpful. Another piece of preparing the official statement, as was referenced before, once there is a continuing disclosure undertaking in place, part of the disclosure for new bond issues is to look back over the last 5 years and do an assessment of the issuer's prior compliance with their other undertakings. And so another reason to be very cognizant and mindful of those responsibilities with respect to those continuing disclosure undertakings, because you have to, if you've missed a filing, or if you've been late, or a piece didn't get filed, you have to confess those sins at the next time that you offer, and those will remain in your offering documents for the next 5 years, so long as you're taking new bonds to market. So it's really important that when that look back is done, that the issuer reviews that as well, and that you work with counsel to make sure you're in agreement as to how that past compliance was done. Another important piece of this process for pulling together an official statement is having time to review. So you, as the disclosure officer, as that key point person, need to be able to look through things and have time to review it, and then making sure that you get it to your governing body with time for review. And so maybe it's something at the beginning of the process that you let the finance team know what your deadlines are for getting materials to your city council or your board of supervisors or something like that, just so that your elected officials have the appropriate time to review those materials before they take official action on approving that document. So ask questions if things aren't making sense. It's really important that you are fully engaged and keeping the timeline that's workable for everyone. If we look and shift gears a little bit towards meeting continuing disclosure obligations once those bonds are issued, we are talking a little bit here about that Rule 15C212 that Dave had talked about earlier, and then also just kind of that reminder that this disclosure is ultimately that of the issuer. So with 15C212, the issuers need to make sure certain pieces of information are filed on that EMMA system. And we'll talk a little bit too about a dissemination agent. So that's, as Dave mentioned at the outset, there can be professionals that issuers retain to help get that information loaded onto that EMMA site. The information has to be searchable, so like a PDF. It's good to make sure that when you take on new bonds, that you do a close, careful review of your new CDC, your new continuing disclosure obligation. Maybe as an issuer, you already have some in place, but it's possible that the tables or information that is required to be provided under this new document could vary from prior ones. Maybe you've had GO offerings prior, and now you've got water revenue. So you're going to have to provide different types of information generally. And so it's good to make sure that you understand what's going to be expected, and again, ask questions and work through that as documents are being pulled together and prepared. So we've broken down 6 things we think you need to know to meet those continuing disclosure obligations. Ultimately, who's responsible? So that disclosure officer has a lot on his or her shoulders, overlooking really this whole process. So making sure those annual filings are done. I like to describe that as those are the known items. So once you undertake a continuing disclosure certificate, there's certain pieces that are carved out that you know about in advance, and you can plan for those. And then there's that other list of 16 items that we've referenced a few times, and we'll reference and have slides on those again. But those are those material events that are deemed so important that you can't wait for the next annual filing. Those are things that might be surprises, and there's such a short window to get those taken care of that you need to be mindful of what those material events are, and then get in touch with the folks here at Dorsey, and we can help you assess whether a material event notice needs to be filed, because again, you've got 10 business days to get that done. Then there also could be certain circumstances where a voluntary filing, or maybe there's something new that is or unique that is also reflected in your CDC. So just kind of keeping an eye on those pieces. With the next part, we've talked a little bit already about those understanding the CDC obligations. And so you've got a good crew of people working with you, a good team that can help you make sure that you understand any of the differences that could be from this, whatever your new CDC is to prior ones. So always pay attention and ask questions. Within the Dorsey policy, we usually create some tracking tables for you just to help meet those obligations. And so there's one portion of that breaks down and lists each of your outstanding issues and tells you your final maturity date, because once you hit that date, your obligations for those set of bonds is over. So that's kind of nice. You can cross that off your ongoing list. But then there's also a suggestion of the different pieces that you want to keep together and in a good spot that you as the disclosure officer knows where those are, and that you've also got a backup if you can. That's one of the things that can be kind of tricky if you're in a smaller office, but it's really important to have some cross training and some awareness for what is expected, because if the disclosure officer moves to a different position or takes a new job, those obligations and responsibilities still are on the issuer's shoulders, and so those still need to be taken on. And so just to ensure that there's also some ongoing training and information sharing so that those duties are going to be picked up. There's also a different portion of that table that breaks down what are the specific items that continuing disclosure certificate requires. So we've talked about audits, and then we've talked and referenced briefly, there's operating data and certain financial pieces of information that would be included in your official statement that would likely be required to be updated and refreshed on an annual basis. And so those would also be part of your continuing disclosure filings. And we can break those down into another table. So you've got kind of a check the box so that you know that you've got all your pieces. One of the things that I often talk to different issuers about is setting some calendar reminders. So if we look at the next piece, we've got a breakdown of different deadlines that are useful and helpful for working through this process. If the issuer has a dissemination agent, they may have a timetable that they work with to gather that information on an annual basis. So make sure you're coordinating with those folks, and then put these items as reminders on your Outlook calendar. And I would also suggest you put them on a reminder for more than one person, and just set them for an annual recurrence. And then you've got kind of a backup there so that you know that you can get those done on a timely basis. With the list of 16 items, number 5, take a look at that every now and again, because they're kind of quirky. And as Dave said, there's that rating change, which could be a positive one, but that still has to get filed within 10 business days. And if it isn't, then the next time you go to offer bonds, you have to say, well, we didn't get certain pieces of information filed on time. 6 kind of outlines a few other things that you want to take a look at. And another piece too is, once these filings are done, you've worked through all the process, you've gathered your information, and you've coordinated with your dissemination agent, go out and take a look. Did those filings in fact show up on EMMA? And if you've got multiple series of bonds, did all of the appropriate CUSIPs get tagged? It's just one more way that you can stay in contact and close connection to that information, because as we've said, it's the issuer's responsibility, even when you've got other folks helping you along with it. So here again, because they're important, we've included these list of 16 items again. Don't try to guess, because as you can see, there's a number of pieces that have a materiality assessment. Maybe there's also a component with financial difficulties, so that can be, usually a way to narrow things down as well. But pull this out, put it on your calendar too, as a reminder from time to time. Talking about annual audits, and so those are usually a piece of the continuing disclosure obligations, one of those pieces of information that is in that known bucket. So something that every year you're going to need to file. Well, as we've seen through COVID, some of those audits were getting slower than usual. And so that can be an issue, but it's not one without a solution. So if you know that your audit or even your other annual operating data, for whatever reason, isn't going to be prepared in a time that would allow you to meet your filing deadline, review your continuing disclosure certificate and work with your dissemination agent, or get a hold of us and we can help too. But you want to do some kind of a filing to either provide some unaudited financials and then a notice that also describes that, we realize we have an audit filing obligation. It's not ready yet, but we do anticipate filing it on, and then you provide kind of a generic time frame. But we can help with that. But it's important to at least kind of raise your hand and say, yeah, we know we have this and we're going to get it as soon as we can. And then once that audit is finalized, then you need to make sure it gets out on Emma just as soon as possible. Because again, that's part of the look back when you have future bond offerings. So moving next to the training, when you've got all kinds of other duties and responsibilities coming at you every day, and we know that you do, continuing disclosure maybe isn't always at the top of your urgent list, but it's really important. And we want to make sure that you've got a process built into your training schedule, both within your staff and with your elected officials. And we've got suggested timeframes for when those occur, and then some documentation recommendations as well. So kind of wrap up a few things here before we check in on questions. Just again, these disclosure obligations are really important. It's part of the process when taking those bonds to market initially, but then it's an ongoing obligation so long as those bonds are outstanding. It doesn't stop once you close. We've had increased scrutiny from the SEC, as James walked through, especially with that school board issue in California from the fall, and just wanting to be mindful of the issuer's obligations and compliance expectations. So James, we'll check in with you on questions.
All right. Yep. And if anyone has questions, yep, feel free to send them even post webinar to my email, and we will follow up after this webinar and get back to you. One question is on financial obligations, and Dave, I'll send it your way. And what are some of the things that we look at when determining materiality for issuers? And obviously we're dealing with all different sizes of issuers depending on the question at hand.
Well, and this is one of those questions again that because you're really dealing with materiality, we can't really give an absolute answer. So one of the first things we have to consider is obviously we have a lot of different size issuers. So an obligation for $100,000 for issuer A may be a pretty material financial obligation depending on the size of the issuer. $100,000 obligation for city B, depending on the size of that city, may fall well below a threshold for materiality. So first concept there, I think, is kind of what kind of impact does the amount of the financial obligation have potentially on the finances of the overall issuer. And then from there, I think you kind of look at factors as to essentiality, a whole host of other contextual items within the financial obligation itself. So I can say this. I think we're fairly resolute that, you know, the copier contract, you know, the kind of small minimal contract payable from your general fund as kind of normal operations of an issuer, that is not a financial obligation that I think we're talking about. I'll just to give you an example of a financial obligation that we do talk about an awful lot in this context for issuers to think about would be a rebate agreement. If you have urban renewal area and you may be entering into agreement as an issuer with respect to a developer, and as part of that development agreement you're going to rebate taxes. Kind of a difficult analysis, but ultimately we've determined that that is technically a financial obligation of the issuer. And so the first part of that analysis is a box check. But then, as you might imagine, it gets a little more difficult because when you're speaking in or deciphering in terms of materiality, well, how much might the rebate be? What's the term of years? So on and so forth. So I would say kind of a broad question, very contextual. Clearly, there's a monetary amount that starts the discussion. And then you kind of have to take a look at what is the agreement or the obligation, what are its terms, and break it down from there to actually reach an ultimate decision on materiality, which is why I would hope that folks don't try to tackle that determination without contacting us to have some thoughtful deliberation about the issue.
Makes sense. And then I think the other aspect of those agreements, we do not always know, and external finance professionals do not always know when those agreements are signed and when they're actually put in place. So that's the other thing to keep good track of. It may be signed by one party, but not both for some period of time. But when it's actually there and in place, that's when the 10 business day clock starts to tick. So that's something to keep in mind as well.
Yeah, if I could just maybe tackle an issue for folks to really think about. One question we've been getting an awful lot of, and this goes to trying to determine, kind of following on to James's point, the period again for filing is 10 business days from the event. This context arises as well when you're trying to determine when potentially was an audit accepted. And I would urge folks to take a look. As Jennifer said, there are a lot of audits. If you're using the state as your auditor, they're quite behind. And so it can be difficult to determine for timing of filing whether you've met the 10 business days, because it can be very hard to determine when was the audit finalized. And by that I mean it gets difficult. Is that when it was received by an email? We're finding a lot of issuers may not actually have a situation whereby the council actually receives and accepts it. And so I would urge everybody to give some consideration with respect to audits, to maybe have the audit received and accepted at a formal council meeting, because then the line of delineation is much more clear, I think, for when should that audit be filed with regard to within 10 business days. It would be not just received from the state auditor or your auditors in general, but in fact, when is it accepted and approved at a city council meeting, which we think is a much better line of demarcation.
All right, with that, we're at our limit. For those that emailed a question and we didn't get to it, we will follow up with you directly. We do appreciate you reaching out. And we certainly appreciate everyone's time in joining us today and hope you have a good rest of your day. Thank you all.
Thank you.